An arbitral tribunal has the authority to implead or join non-signatories to an arbitration agreement as parties to the proceedings, provided they are found to be bound by the arbitration agreement under the group of companies doctrine or other legal principles establishing their intent or involvement, as laid down in Cox and Kings v. SAP India. The tribunal's jurisdiction is derived from the arbitration agreement itself, not merely from the referral court's order under Section 11 or the Procedural Act of Tribunal Constitution. The doctrine of competence-competence under Section 16 empowers the arbitral tribunal to rule on its own jurisdiction, including the joinder of non-signatories, without dependency on national courts. The tribunal can exercise necessary powers to effectually decide jurisdictional questions even in the absence of a challenge by the parties. Non-service of a notice under Section 21 does not nullify the arbitral tribunal's jurisdiction to implead a non-signatory. Section 21 is procedural, aimed at determining the commencement of arbitral proceedings for limitation purposes under Section 43, and does not restrict the tribunal's jurisdiction to claims or parties not specified in the notice. Additional claims or counterclaims, including those involving non-signatories, can be raised under Section 23, provided they fall within the scope of the arbitration agreement. The group of companies doctrine applies where non-signatories are inextricably linked to the performance of the contract, share common management, or demonstrate mutual intent to be bound by the arbitration agreement. In this case, the appellant ABPL, as part of the ASF group, was correctly impleaded due to its substantial involvement in the negotiation, performance, and termination of the works contract and settlement agreement, evidenced by common directorship, shared resources, and representations as a single economic unit. The High Court's dismissal of the appellant's appeal under Section 37, affirming the arbitral tribunal's rejection of the Section 16 application, was upheld. The tribunal's findings on the applicability of the group of companies doctrine were supported by material evidence, including correspondence, the comfort letter, and the intertwined nature of agreements involving the ASF group entities. The Arbitration and Conciliation Act 1996 lacks express provisions for the tribunal's power to implead non-signatories, causing procedural uncertainties. The proposed Arbitration and Conciliation Bill 2024 also fails to address this issue. The court urged the Ministry of Law and Justice to consider statutory recognition of such power to enhance clarity in arbitration law. Appeal dismissed. All legal contentions kept open for adjudication before the arbitral tribunal.